All right, the court is calling 2023 CR 4371B, State versus Marco Antonio Moreno-Vasquez. We have the interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God? All right, you can lower your hand if you'll state your name for the record.
Abrams, license number 2081.
All right, could the parties introduce themselves for the record, please?
Megan Galloway and Warren Espinosa for the state.
David A. Garcia, attorney for Marco Moreno-Vasquez.
All right. Are there any amendments to the indictment or?
Judge, at this time, the state moves to waive an abandonment count for the indictment and proceed on counsel.
Any objection?
No objections, Judge.
All right, then count three will be waived. Are both parties ready to proceed?
The state's ready, Your Honor.
Defense is ready, Judge.
All right, you both will have 40 minutes.
When are your mics spelled, Cindy?
Cindy, one of your microphones fell.
Well, if they could just set it back up on one of
Just
the,
put it on the pen.
should still have a piece of tape on it.
Oh, yes, he can come in. You're welcome. All right, everyone, please be seated. Good morning, everyone. Wait a minute. You all should already be wide awake. You have to stay downstairs as long as other people are. You got assigned to a courtroom right away. So we're going to try that again. Good morning, everyone. Good morning. See, now I know everybody's awake. And you can't complain about the rain because we were asking for rain. And so you have received what you've asked for. All right, everyone. You are in the 187 District Court. It's on the 4th floor, and I'm Judge Boyd. So let me see how we're doing. What floor are we on? What's the court number?
7.
What's the judge? All right. Now you're probably saying, why is she asking us these questions? We know where we are. The reason why I ask those questions is because guess what? If any of you ever need a break or we take a break, you all have to step outside. Nobody can stay inside. So with that being said, if you ever need a break, just raise your hand and let us know that you need a break. And so you will have to leave. Everybody will have to leave. And it never fails. When that happens, we always are missing a juror. And then the deputies have to find them. There are announcements made throughout the building. And we find that person trying to go to another courtroom and they say, you know, I looked up, everybody was gone. So if you ever lost, if you just remember the 187 District Court, I don't care where you are in Texas, there's only one 187 District Court. There's only one Judge Boyd in Bexar County. So if you ask anybody those things and say, I'm looking for the 187 or I'm looking for Judge Boyd, you will be directed here. So this is the state of Texas versus Marco Antonio Moreno-Vasquez. I'm going to have the parties introduce themselves to you.
Good morning. My name is Megan Galloway and I represent the state of Texas.
Good morning. My name is Lauren Espinoza and I also represent the state.
Good morning. My name is David Garcia. I represent Marco Moreno-Vasquez.
All right. So, ladies and gentlemen, we also have an interpreter here. And the interpreter, if you could state your name, please. All right. And then we have an interpreter in training with her. If you could state your name. All right. And then you can see we have someone in the witness box who is not a witness. What is your name, please?
My name's Andrea Vera.
All right. So sometimes we have people here who are thinking about different occupations. So they come in like to view so they can decide if this is something they really want to do. She, I believe, is with the state. Yes. And I think she's an intern with the state. And then we have the other prosecutor here.
Good afternoon, everyone. Morning.
And that is your name, please.
Sorry, good. My name is Brandon Breeder. I'm with the state of Texas.
All right. So you will see people come into the courtroom. Maybe they're just here to watch. Sometimes people will come through that door. They're coming through that door because they didn't read the sign that says we're in a jury trial. Do not come through this door. Sometimes people will come through this door. Just ignore the people who are coming through this door and this door. The people coming through this door are for me specifically. Usually it's for orders to sign. It's something that's unrelated to this trial. I just want everyone to make sure that you focus on the trial. Does everyone understand? All right, so the parties have stood up and introduced themselves to you, and even the people who are just here to learn, raise your card if you recognize any of the parties who've introduced themselves to you. All right, so no one has raised their cards. To my left is the court reporter. Cindy takes down everything that everyone is saying. That can be difficult. The reason why it can be difficult is because guess what? Some people want to mumble. Some people speak very fast. Some people whisper. We can't do that because Cindy needs to hear. And the acoustics in this courtroom is horrible. Have you all been able to hear me in the back? All right, if there's any time that I'm speaking or either party is speaking and you can't hear, please raise your card. Don't sit through the entire voir dire and then at the end say, I didn't hear anything. Now, we're gonna practice with your cards. Everyone raise your card. And don't lower your card until I tell you to lower them. And please make sure your numbers are facing forward. Thank you, number 16. All right, so when I tell you to lower your card, I'm gonna need you to lower your card. Do not lower your card, number 75, I can't see your number. Turn it around, thank you. Do not lower your card until I tell you to lower your card. Jurors 1 through 21, lower your card. Anyone else with your card still held up, this is what I need you to do for me. If somebody's asking you a question, if you're answering a question, if you can stand, I will need you to stand when you answer that. That's so everyone can hear. Is everyone able to do that for me?
Yes.
If you all do that, you will be the first jurors who've ever been able to do that for me. So I have faith in you. So you can lower your cards. Now, I want to talk to you about this case just briefly. One, the charge in this case, count 1 is murder, count 2 is deadly conduct. And I'm going to come back to you and talk to you about ranges of punishment. What I can tell you is when I speak to you, one, I'm not speaking about the specific facts in this case or what people think the facts are in this case, because number one, I don't know the facts in this case. Number two, the state and the defense are not allowed to tell you what they think the facts are in the case. They're only able to speak to you in hypotheticals. So when they're speaking to you, don't be like Mrs. Kravitz from Bewitched and saying, this is what this is about. No, just listen to what they're telling you and know that they are only speaking in hypotheticals. Does everyone understand?
Yes.
Now, I want to talk to you about indictments. What are indictments? What do they mean? An indictment is just a piece of paper. And the indictment is designed to tell anyone who's accused of a felony offense what they're being accused of. It's a sheet of paper. That sheet of paper is for the person who's accused. It's not necessarily for jurors. So what am I trying to say to you? One, just because somebody's indicted for a felony, you can't hold that against them and say, oh, you've been indicted, so that's a strike against you. You are not allowed to consider that someone has been indicted. You are not allowed to hold it against them. You're not allowed to take that as evidence of anything. Does everyone understand?
Yes.
Let me give you an example. Raise your card. We're going to practice a lot raising our card. Raise your card if you've ever had a traffic ticket. All right. So the people who didn't raise your cards, I'm so sorry because you have to drive for everybody else. But this trend continues. There's some horrible drivers here in San Antonio. All right. You can lower your card. So let's say you get a traffic ticket. An officer pulls you over. That officer says, you ran a red light. Well, when they give you that ticket, they will put on there what they're accusing you of. And they'll tell you where you need to go if you want to have a trial. Usually it's the municipal court on Frio. And on that ticket, it'll tell you, you don't have to come in if you don't want to, you can just pay the fine, right? Well, when you accept that ticket from that officer, you're not saying, yes, officer, you're correct. I ran the red light. You are accepting that ticket because that's to give you notice. So when you go to municipal court and you're like, you know what? I'm going to trial on that because I know for a fact I didn't run a red light. So you get to municipal court, you're ready, you're doing jury selection, and you're like, I got them because I ran a stop sign, not a red light. Then lo and behold, you're in the middle of trial, witnesses are being called, and the officer's like, oh yeah, they ran a stop sign. And you're like, wait a minute, I'm supposed to be here just for running a red light, not a stop sign. I'm not prepared for this. So as you can see, an indictment is just putting somebody on notice. Does everyone understand?
Yes.
And the law says you cannot hold it against them or consider it as anything. Does everyone understand?
Yes.
Is there anyone here, raise your card, who's going to hold it against the accused just because he is here under indictment? All right, that's number one. All right, now the next thing I want to talk to you is certain rights people who are accused of an offense has. One of the rights is the right to remain silent. If you've ever seen Paper Chase, Mannix, Beretta, The Practice, thank you, you know what I'm talking about. Then you know that everybody has a right to remain silent. What does that really mean? That means you don't have to testify if you don't want to in a criminal case. So that means that the state can't say, oh, my next witness, I'm going to call the person who's accused. They're not allowed to do that. When you are going to trial, a person who's accused of an offense has certain decisions they can make. One is whether or not they will testify, whether or not they're going to jury trial. Those are some of the things that they're allowed to make choices about. So our Constitution says you don't have to testify. You can remain silent. Now, I always ask jurors, will you hold it against somebody if they choose not to testify? And I always chuckle because some jurors will say, well, if that were me, I would get up and tell my story. And I laugh inside because I'm like, that's not you. And let me give you a hypothetical to that. Let's say you've been having chest pains and you go see a specialist and the doctor says you need heart surgery and you need to have heart surgery today. And you're like, I know you're the expert and all, but I'm going to get a second opinion. So you go to the second specialist. The second specialist, like, yeah, you need heart surgery and you should have done it yesterday. And then you're like, yeah, I know you're an expert, but I'm going to go to the third person. You go to the third person and you see that doctor, and that doctor's like, I don't even know how you're still living. We need to get you on the table right now and do surgery right away. So you're like, you know what? I'm going to go along with what this expert is saying. I'm going to let them do surgery. So when they're getting ready to do surgery, you tell the expert, this is the scalpel I think would be best used in my case. And this is how I want the stiffness to be. You wouldn't do that. Why? Because that's why you went to an expert. I've been a defense attorney. I've been a prosecutor. And let me tell you, usually people who are accused of offenses, they have a discussion with their attorney and they together make a decision on, would it be best for you to testify or not? Sometimes I would have clients as a defense attorney. I would sit in the office, talk to them, and I would say, I am doing, my best for you. I'm representing you and I'm for you. And you're sweating in the office talking to me. You would not be a good witness. Then you have some people who maybe have speech impediments. And they're like, people are going to look at me different, maybe hold it against me, and I can't get my words out. Then you have some people where, as an attorney, I would tell some clients, the state can prove their case. There's no need for you to say anything. You don't need to testify. So our law says if someone decides they are not testifying, you can't hold it against them. You can't consider it. You can't be in the back room deliberating and say, well, that's a strike against them because they didn't testify. Or let's talk about the reason why they wouldn't testify. You're not allowed to do that at all. Does everyone understand? Is there anyone here, raise your card if you're going to hold it against Mr. Vasquez if he decides not to testify? All right. Now, the next thing I want to talk to you is presumption of innocence. Everyone who is charged with an offense is presumed to be innocent. What does that really mean? That means that the state has to prove their case. That means that the defense does not have to do anything because their client is presumed to be innocent. When we're in law school, and every person who is an attorney, they had that one professor, and that professor would tell them, you can play crossword puzzles at your table. You can play video games at your table. You cannot listen. The reason why they were telling that to us, because they wanted us to know that, one, as a defense attorney, you don't have to put on any evidence. As a defense attorney, you don't have to question anybody. As a defense attorney, you and your client can sit and do video games and crossword puzzles. Why? Because the defendant is presumed to be innocent, and the defense never has the burden to prove anything. Does everyone understand? The burden rests totally with the state. So they have a burden. What is their burden? Their burden is called proof beyond a reasonable doubt. When I was in law school, you had to know that definition. You had to know it forwards and backwards. I knew it forwards and backwards. When I had my first jury trial, I knew where to put the comma. I knew where to put the exclamation point. I knew where to pause for dramatic effect. And after that trial, guess what? They took away the definition. There is no longer a definition for proof beyond a reasonable doubt. So when I was trying cases, I said, well, how am I going to explain this to the jury? Because I don't want them to find my client or use a burden that's less than proof beyond a reasonable doubt. And then when I was a state's attorney, I said, well, I don't want them putting our burden beyond what it's supposed to be. So how can I explain this to them? So I would explain it to jurors by telling them what it is not. Next door, and my sense of direction, I always say next door, but they tell me it's this way. The civil courthouse with the green rooftop, the historic courthouse, they handle civil cases. Fender benders, somebody suing somebody for money. Those are the type of cases they do over there. So one of their burdens is called preponderance of the evidence. Preponderance of the evidence is more likely than not something happened. If you're on a criminal case, I don't care if it's misdemeanor court or felony court, if you are deliberating and somebody on the panel starts saying, I believe more likely than not this happened, you need to tell me, excuse me, let me let you know, we're in the criminal courthouse, we're not on the civil, you're at the wrong burden of proof. So proof beyond a reasonable doubt is higher than that. Then their highest burden is what's called clear and convincing evidence. Clear and convincing evidence is evidence that is presented that is used to terminate somebody's parental rights. They're saying you're a danger to your child. Legally, we're not going to let you be a parent anymore. That is their highest burden. But the highest burden we have in the land is proof beyond a reasonable doubt. Does everyone understand? Now, I want to talk to you about fairness. And what does fairness mean? Because people always say, can you be fair? Sometimes you have jurors, they're like, man, I was hoping I was going to get a fender bender case. Here I am on the criminal side. This is what fairness is. Let's say you get up, you get a card in the mail saying you have jury duty, and you're excited because you want to do your civic duty. So because you want to make sure you're on time, you do a test run the day before, you map out your routes, you see where there's construction, and then you say, let me see where I'm going to park. You know where you're going to park, so you know how to avoid the one-ways, you know where they are. So you get the forecast, they tell you it's going to be heavy rain. And you said, you know what, I'm going to get up extra early because I know it's going to slow things down a little bit. So you're drinking your coffee, you get up extra early, you have your umbrella, you have your lunch, you come downstairs, and your car is on cinder blocks. Somebody has taken your tires, they just destroyed your vehicle. And when you come up to a courtroom, you learn that you're going to be sitting on a burglary of a vehicle case. Usually people will ask you, this really is not the case for you. You really can't be fair in this situation. This is what fairness means in that situation. What fairness means is if all of that happened to you and you're called up for a burglary of a vehicle, if you're sitting on a jury, would you base your decision on whether somebody's guilty or not guilty, if you can come to a decision based upon the facts that are presented to you? Or are you going to say, you know what, my car was burglarized. I don't care if this person did it or not. That's a strike against them. That is basically what fairness is. Because guess what? Raise your card if you were born yesterday and slept all last night. So that's nobody. So you know what that means? That means that nobody's had a perfect life. Everybody at some point in their life has had something bad to happen to them or a family member. Does everyone understand? So that's what fairness means. So is there anyone here, if you're selected on this jury, will not be able to sit and listen to the evidence that's presented? And if you can come to a decision, base your decision upon the evidence that's presented. Is there anyone here who can't do that? All right, so that's 1, 6, and 40.
Left off 3, Judge.
Oh, I'm sorry,
11.
number 3 and 11. Thank you. All right, now the next thing I want to talk to you about is ranges of punishment. I told you count 1 is murder. The range of punishment for murder in Texas is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And all of the felony charges, majority of them, it's a $10,000 fine. Now, where that money goes, nobody knows. It's supposed to go in the coffers of the state of Texas courts, but so we're not even going to focus 100% on the $10,000 fine because nobody knows where it goes. Now, let's talk about the range of punishment for murder. The range of punishment is 5 to 99 years or life. What does that mean? That means if someone were to be found guilty of murder, you can decide to sentence them 5 years, 6 years, all the way up to 99 years or life. Does everyone understand the range of punishment? Now, so the question is, have you internalized the range of punishment? Has everyone done that? Internalize. When I say internalize, you've internalized that the law says that the range of punishment for murder is 5 to 99 years or life. And that can go from 5 years all the way through all of the way the numbers up to 99. Does everyone understand?
Yes.
Now, so the question is whether or not you can consider the full range of punishment. And usually sometimes jurors get confused. They're like, well, I don't know if I can give 5 years for murder. That's not the appropriate question. The appropriate question is whether or not you can consider the full range of punishment. That means internalizing, this is what the range of punishment is. So you can't sentence somebody to 2 years for murder because that's not within the range of punishment. Does everyone understand? So let me give you some hypotheticals. Let's say you have 2 couples. They've been friends throughout high school, all through college years. They end up getting married. So you have one couple, they married to their sweetheart. The other couple, they're married to their sweetheart and they're best of friends. And the women end up getting pregnant at the same time. One has a girl, one has a boy, and they start planning. They're like, wouldn't it be great if our children ended up getting married? So they're constantly throwing them together. They're in the same preschool. They go to the same elementary school. And lo and behold, the children grow up and they end up getting married. And they have their children and they age together. Their parents ultimately pass, so it's just them. Then one of them, in their later years, gets very ill. They go see an expert. Expert tells them, there's nothing we can do. This person is going to die, and it's going to be extremely painful until they die. But you know what? They're like, we're going to another expert. They keep going to experts. Experts tell them the same thing. So one of them ends up in the hospital, and they tell their spouse, I love you. And they're like, honey, I love you too. And the spouse says, look, I haven't been taking the pills that they've given me, and I'm in so much pain. Can you help me end it all? Because I just can't take the pain anymore. And so that spouse, you know, in tears, but the spouse like, yeah, I'll do this for you. And they help them. And that person dies. That's murder. Now that's a case where you may say to yourself, yeah, I could consider giving 5 years for that. Now, let's say you have the second scenario. You have somebody who's been in school, used to kick the cat on the way home, throw paper in the street, sees an old lady walking across the street when they're a teenager, pushes her down, steals her purse, and is constantly doing things like that. And everybody says, you know, that person's going to end up killing somebody. And ultimately, that person ends up killing somebody. And let's say you find them guilty of murder. Then for that person, you may consider the higher range. Does everyone understand? But the key point to considering ranges of punishment is, if you were to find someone guilty of murder, would you be able, if you can come to a decision on punishment, would you be able to base your decision upon the evidence that's presented to you? Does everyone understand?
Yes.
Is there anyone who would not be able to do that? All right. And the next thing is deadly conduct, and that's count 2. And the range of punishment for that is anywhere from 2 to 10 years in the prison. So again, 2, 3, 4, all the way up to 10, or potentially probation. So again, internalizing that range of punishment, and I can give many examples of that as well. Whatever evidence that's presented to you, if you were to find someone guilty of deadly conduct, if you can come to a decision on punishment, would you be able to base your decision upon the evidence that's presented to you? Is there anyone who would not be able to do that? And what I'm going to tell you is that neither party, again, can tell you what they think the facts are in this case. So they can't tell you what the facts are and say, you know what, let me get your opinion now. What would you give? And these are the facts I'm saying they are. What's the punishment you would give? And I think you can see how that would be unfair, right? Because we want jurors who know nothing about the case and just basing your decision upon what you hear. Now, the next thing I want to talk to you about is certain concepts. How many of you have ever heard the words co-defendants or law parties? Raise your card if you've ever heard that term before. All right, so I see many of you have. You can lower your card. So let me explain to you the law about co-defendants or parties. So you cannot convict somebody based upon the testimony of a co-defendant unless there's corroboration. So, and that corroboration has to be other evidence than the co-defendant saying this is what happened that tends to connect the defendant with the offense committed. So hypothetically, let's say you have a co-defendant comes in and let's just say it's a burglary of a habitation, right? And so you have two people who are charged with burglary of a habitation. One person is on trial for burglary of a habitation. Maybe the other one is going to trial later, or maybe the other one has entered a plea. Is everyone following my scenario so far? All right, so let's say the co-defendant who is not on trial comes in to testify. And when the co-defendant comes in to testify, the co-defendant's like, yeah, I committed that burglary of a habitation with the defendant. He and I went into the house and we stole everything. We kicked in the front door. And that's his entire testimony. And let's say that that person testifies and that's the only evidence the state brings you, that person testimony, nothing else. The law says that you will not be able to convict because all you have is that co-defendant's testimony. So in order for a conviction to occur when you have co-defendants and there's a co-defendant that's coming to testify, you have to have the co-defendant's testimony and you have to have other evidence that tends to connect the defendant to the offense committed. And just because a co-defendant comes in and says an offense was committed and there's nothing else, that is not enough. Does everyone understand? Number 56. All right, so let me go into greater detail. All right. So let's say you have co-defendants and we're going to call John Doe and Jane Doe. All right. And let's say that John Doe is on trial for burglary of a habitation. Jane Doe comes to testify. And Jane Doe is coming to testify to say, yes, I was there on that night. John Doe and I kicked in the front door of this person's home. John Doe and I went in and we stole their watches. We stole their televisions. Okay? So that is a burglary of a habitation. The only evidence you have is Jane Doe coming in and saying that's what happened. That's it. According to Texas law, that is not enough to find somebody guilty. What you would need is you would need their testimony plus other evidence that corroborates what that witness is stating. Do you understand? 56, you understand it now? Okay. Anyone else needs any more clarification on that? And then, as I said before, that corroboration, it has to be more than just showing that an offense was committed. All right. So you need, if you're going to bring in a co-defendant to testify, you need the co-defendant's testimony plus other evidence to corroborate. Does everyone understand? All right. Now, the next thing I want to talk to you about is languages. I love languages. I think languages are beautiful. I'm originally from Louisiana. You can tell when I have to say words like all and soul. My friend told me when we were in school, she's like, Stephanie, come take Spanish with me. I said, absolutely not. I don't need Spanish. We're in Louisiana. I'm going to learn French. And then by the time I'm 21, I will be retired, enjoying my life in Paris. And here I am, 22, and that has not happened. I always tell everyone, if my Spanish is not where it should be, you need to blame the deputies. They're supposed to be teaching me. I'm a great student. I need to start looking towards my teachers. So when I was in undergrad, grad school, and then law school, many people who are from the Middle East and different places, they speak so many languages. Continent of Africa, everybody speaks no less than 6 languages. I was so jealous, but they would try to teach me. So I can probably say hurry up in every language. That's the only thing I was able to learn. Navajo, extremely hard. I see why they had them as the wind talkers, because Navajo, difficult language. So I need you all to raise your card if English is not your primary language and you have not been able to understand anything that I've been saying. All right. So in this case, we are using an interpreter. This is what I can tell you about an interpreter. Some of you may speak Spanish, so the interpreter is interpreting from English into Spanish and Spanish into English. But this is what I can tell you. If you speak that language, you're not allowed to do your own interpretation. So we depend on the professional interpreter, and her interpretation is what is being said. Does everyone understand? Yes. So you cannot say, well, lean over to your neighbor or somebody and say, you know what, they're interpreting that incorrectly. You're not allowed to do that. If she says the word Tia is uncle, then guess what? Tia is uncle, whether you think it means aunt or not. Does everyone understand? Yes. But she's not going to do that because she's excellent at her job. Now, sometimes people will use interpreters because, one, English is not their first language, and maybe they don't feel comfortable. Sometimes it's because, hey, look, I'm fluent in English, but it's not my first language, and this is some serious business here. So I want to make sure that I'm understanding the terminology. And then sometimes I will tell you, you have interpreters who go to school, and the reason why they're going to school is because they have to learn the legal terminology. Does everyone understand? So in this case, Mr. Moreno-Vasquez is using an interpreter. Is there anyone who's going to hold it against him because he's using an interpreter? All right. Now, the next thing I'm going to talk to you about is 2 stories. They're both true. I always tell jurors this: jury duty is an inconvenience. It is not a sacrifice. It's nowhere near sacrifice. Why is it an inconvenience? It's an inconvenience. Oh, I'm sorry. Before I say that, Anyone has any time constraints? We're going to start with testimony in this case this afternoon. I expect this trial to be concluded by Monday, maybe sooner. Anyone who has any time constraints with regards to those parameters, raise your card. I'm gonna let it marinate, then you all can raise your card because once I call your number, I'm not gonna come back to it, okay? So that's number 2, 4, 6, 9, 10, 11. Oh, you can lower your card once I call your number. 15, 16, 22, 26, 28, 29. And if your number is not facing me, I'm going to skip over you. 30, 34, 37, 48, 49, 51, 55, 59, 60, 61, 66, 67, 69, 75, and 74. All right, 74, what's your time constraint?
Today and tomorrow.
You need to stand up.
Oh, today and tomorrow.
Yes, but what is the issue?
I take care of an elderly. My mom, she's 92, she has Alzheimer's, she lives by herself, and I watch her daily.
All right, thank you. 75,
I have job interviews on Friday.
what time? All right, thank you. Number 69,
The reason is I'm going on a trip this weekend from Thursday to Sunday,
where to?
South Padre,
Why?
for a friend's birthday.
Isn't it gonna get rained out? All right, thank you. 67,
Because of work.
all right, thank you. 66,
I'm at a funeral that I'm attending on Thursday morning.
I'm sorry to hear that, what time?
Things at 10:30.
All right, thank you. 61,
Work.
all right, thank you. 60,
Work.
thank you. 59,
Work and childcare.
what's your childcare issue?
I have somebody 15 minutes.
What time do you take them?
7:30.
And when's pickup?
Order.
All right, thank you. 59, 55,
It's work.
all right, thank you. 51, 49,
Work.
48,
I'm out of town for work on Thursday.
all right, what are you doing there?
I'm a nurse and I'm in training in Houston.
I'm sorry, could you?
I'm a nurse and
Yeah.
I'm in training Thursday and Friday in Houston.
All right, thank you. 37. Number 37,
Possibly traveling to Mississippi with family over the weekend
for what purpose?
to visit family,
All right, and what day?
Friday to Sunday.
Do you really want to visit family?
You know,
Okay, I'm gonna take that as a no. All right. Number 34,
Got to a hospital and to anyway, I can't remember.
all right, what date and time
Thursday,
and what time?
I think it's around 10 o'clock.
All right, what, are you married?
Yes,
All right, what does your wife have on the time thing?
this is her wife.
Usually the women know what time it is. Number 30,
Work and childcare.
what's the childcare issue?
She has to go to summer school, the last day of summer school, complete her finals.
What is the drop off
It's at 8,
and pick up?
up to I think at 12, whenever she's done with her finals.
All right, thank you. 29,
Work.
thank you. 28,
Work.
26,
Work.
22,
Work hours.
16,
Childcare and a trip over the weekend to the LP care.
all right. And when is the trip?
We're leaving Friday.
I'm sorry?
We're leaving on Friday,
Okay. What time?
right around 3.
Number 15,
Work.
11,
Work Wednesday, Thursday, my wife has surgery, and then Friday I have to watch my son, because my wife will be recovering.
all right. 10,
Work and a doctor appointment at 10 on Friday.
9,
I watch my grandsons Wednesday through Friday.
6.
It's work and taking my mom to a doctor's appointment on Friday
What time is the doctor's appointment?
at 10.
4,
Doctor at 9:40.
I'm sorry, what?
Doctor, 9:40,
What day?
Friday.
Thank you. Number 2,
Work and childcare,
when's pickup and drop off?
pickups on Fridays at 5:30 and I have them till Monday.
All right, thank you. All right, so back to my 2 true stories. Jury duty, it's an inconvenience. It's not a sacrifice. It's nowhere near a sacrifice. It's inconvenient because you have to drive downtown. It's inconvenient because you're sitting on hard benches, which you should contact the commissioners about that because I'm not in charge of that. It's inconvenient because you have to pay for parking. You're probably saying, why do I need to pay for parking? I'm helping you all out. Not in control of the parking. This is what I say a sacrifice is. My family grew up in a small town called Grand Cane, Louisiana. Town where everybody knew everybody. The teachers not only knew all of the students in their class, they knew all the students in school. So my grandmother's firstborn, my uncle, ends up going to high school. And they would tell my grandmother, they would say, Miss Lane, we've taught him all we can teach him. And they'd move him to the next grade. Now, when his brother and sisters end up going to school, they didn't like that too much. You know why? Because the teachers told them, this is the gold standard, and this is what we're expecting of you. So my uncle ends up graduating, and there's a conflict that breaks out. You may have heard of it, called the Vietnam War. My uncle goes to my grandmother and says, because of civil rights and what's going on, there's no way for me to improve my lot in life here. And my uncle was super intelligent, knew about computers and everything before other people did. So my grandmother has to sign for her firstborn child to go off and fight in a place that she knows nothing about. My grandmother had a 6th grade education, but she was super intelligent. She babysat me while my mom was at work. She taught me how to read and write. I knew about Erica Kane and Raven. You know who I'm talking about. I knew how to answer the phone. I knew how to tell the insurance salesman, we don't want any. I did say yes to the childcraft books and encyclopedias, which my mom saw the bill for that, but I still have them to this day. Now, when my grandmother sent her firstborn off to war, young people, it wasn't like it is today. My grandmother, if she were alive, would be shocked that you can take a photo and send it to somebody, they'll have it the same day. She would be shocked that you can video call someone. So my grandmother did have a phone. The phone didn't have any numbers on it. You can always tell the era people are born in by their index finger. I'm from the rotary era, trying to win prizes from the radio. When we got redial, oh my gosh, that was like, wow. So her phone didn't have any numbers. So how did she reach people? You would pick up the phone, the operator would answer, and you would tell them who you would want. That's why you would have songs like Beechwood 45789, because you want the person at Beechwood 45789. She did have a television. It had 3 stations, ABC, CBS, and NBC. The way the weather is today, you would not be able to get NBC, because to get NBC, the weather had to be perfect. That means no breeze. If you got a breeze, there was going to be static. No amount of aluminum foil on your rabbit ears is going to make NBC play any better than what it was. Then the way you young people like, oh my gosh, you know, there's everything on TV, but there's nothing to watch. I've seen it before. Guess what? Back in the day, programming would end. You would know it had ended because they would play the national anthem, and either your screen would just have static on it, or either they'll leave the American flag blowing in the wind. So my grandmother would write to my uncle. She had his name, she had his ID number, and a lot of the men in my family have joined the military. So I'm sure it was the same back then, the way it is now. Wherever your boots hit on the ground when you leave your home, you need to write a letter letting people know, your loved one, whoever it may be, write them a letter and let them know that you have arrived. So my grandmother had to sit, watch the news, see what's going on with her baby. And I used to always end that story right there. And then the deputies are like, Judge, what happened to your uncle? Well, my grandmother realized you do not want to get that knock on your door, because if you get that knock on your door and people are in uniform, not good news. So my grandmother got the knock on the door from people in uniform that her son had been severely wounded in the war. He did survive. He made it back. He continued doing his time in the military. He would go to different places. And because I was the youngest niece at the time, I would always get the presents. He would come in, hug me. That is why to this day, whenever I smell Old Spice, it makes me think of him, because Old Spice back in the day was the rite of passage for men. You knew you had reached manhood when you were able to use Old Spice. So he's since passed, and some of my aunts have since passed, and my grandmother. But I tell that story to you to tell you that's what a sacrifice is. Sending your firstborn off somewhere that you don't know anything about, you're not getting updates on, and you sending them into danger. Your country only asks two things of you. They ask for you to pay your taxes and show up for jury duty once in a blue moon. That's all they ask of you. And I see people, Veterans Day, 4th of July, Memorial Day, people raising their flags, support our troops. But then when your country asks you, because they don't even have the draft anymore, when your country asks you, hey, can you give us, 3 days for jury duty to listen so that we can uphold the Constitution and somebody can have a jury trial? Usually people try to get out of jury duty. Usually people say, oh, I have other things that I have to do. So this is the inconvenience your country is asking of you. They're not asking a sacrifice. Each side is going to have 40 minutes to speak to you. I had a friend in law school. She ended up having jury duty. She practiced civil law. And she said, Stephanie, I'm free. Let's have lunch. I have jury duty. I'm like, great. So we're having lunch. I asked her, how's jury duty going? She's like, oh, it's going great. I'm like, that's really odd to say that it's going great. I said, why do you say that? She said, because it's like law school. I'm on the back row. I'm keeping my head down. Nobody has called on me. And I said, well, I am very happy and ecstatic. She said, why? I said, because we're going to be able to have lunch all week. So other than raising your hand saying, please, I want to be in this jury, the quickest way to be on this jury is not to say anything, because both sides, they don't have time, regardless of what you've seen in Runaway Jury and all of these other movies. They don't have time to go out to your house, sit with you, talk with you. They don't have somebody who's going to be going in your trash can to see if you would be a good juror or not. So, anyone need a break before I turn it over to the state? All right. So, everyone, look to your left, look to your right. You're responsible for that juror. So this is what's going to happen. I'm going to give you all a 10-minute break. Oh, you're responsible for them being in line. So I'm going to give you all a 10-minute break. Everyone must leave the courtroom. You must leave your numbers behind. When you are back, do not come in the courtroom. You have to be lined up outside in the same order, and then we will bring you back in. Is everyone going to do that? And you know who you're responsible for. All right, thank you. All right, everyone, please be seated. And ladies and gentlemen, I'm going to turn it over to the state. Each side will have 40 minutes to speak with you.
Thank you. Good morning, everyone. So as I stated earlier, my name is Megan Galloway and I represent the state of Texas. And I have a confession to make to you all this morning. So I want you to think back to earlier this morning when you were on your way down to the courthouse. And I'm sure that the rain was coming down really hard, just as it was for me. And it's no secret that there's a lot of construction that's going on downtown right now. And so this morning I was running a little bit behind because of the rain. And I came to this merge section where usually I would, allow the person that needed to untimely merge to merge. But this morning, because I was running late, I said, you know what, I am so sorry, but I cannot allow you to do that this morning. And so I say that to say to you all, if I stand here before you today and you say, hey, that is that jerk that didn't let me merge this morning, speak now or forever hold your peace, okay? So in Judge Boyd's presentation to you all, she let you all in on the best kept secret in the courthouse. And that is that people that do not participate or want to stay quiet are likely the ones that are going to end up on the jury. And so I'm asking that you participate and let us know your feelings. This is a judgment-free zone, okay? And I know you're feeling like, please, please, please don't call on me. But I'm gonna have to call on you, especially if I don't have volunteers, because like I said, if you stay quiet, you are going to end up like people impaneled and look at how happy they look to be on that jury. So when you all were coming back in, I know some of you had questions as to whether when we all stand, whether y'all have to continue standing. I just wanted to let you all know that we stand for you and thanks for your service. Okay, so we stand for you. Once you're in, you're able to sit down. And so I want to talk to y'all about the purpose of jury selection. Judge Boyd kind of went over this with you all already, but the purpose of jury selection is to talk about the law that would apply in the case and to the charge that Judge Boyd has informed you of, and learn about your thoughts regarding the law and find 12 fair and impartial jurors that are right to sit on this case. Okay, both the state and defense want fair and impartial jurors. And so who can tell me who this is? Raise your card. We'll just go juror number one. Who is?
Who's what now?
Who's depicted in the photo?
Oh, Willie Nelson.
And what does Willie Nelson love? We'll go juror number 30. Lead? Okay, right? And so what kind of case do you think Willie Nelson would not be a good juror on? Drug, and specifically, right, marijuana possession, right? And why is that? Because he fundamentally disagrees with the law, and everyone is entitled to their opinion regarding that. But he believes that marijuana should be legal, right? And so that's a fundamental disagreement with the law. And so what I have a rule in my jury selection PowerPoint, and it's called the Willie rule. And I'm gonna refer back to it because what that means and what I need the answer to is, do you understand the law? Do you disagree with the law? And even if you disagree with it, can you follow the law? Okay, does everyone understand that? Does anyone have any questions? Okay. The second rule that I have during my time with you all is no waffling. Okay, I do this a lot, and every single time that I present to a jury panel and I'm asking a question, I get somebody and they think kind of like the little engine that could, I think I can. So I'm going to be asking you all a series of questions as well as defense, but we need definitive answers. So that's yes or no's, and pick what aligns most with you. Does everyone understand that? Okay. Now, we talked about the burden of proof, right? The burden of proof in a criminal case is beyond a reasonable doubt. That burden rests solely upon the state, okay? And so the judge informed you that there's no legal definition for that. And so we can't tell you what it is, but we can tell you what it is not. It's not beyond all doubt. It's not beyond the shadow of a doubt. And it does not mean that you're even 100% sure. If you were 100% sure, does anyone know what that would make you in the case? A witness, right? Because you were there and you saw. Okay. And then regarding the burden of proof, that goes to the elements. Okay, so those are the elements that we have to prove, and I'll go over those with you in just a bit. Does anybody here own pets? Raise your hand. Okay. Can anyone tell me what happened here? Raise your card, please. Okay, what happened in this photo?
Well, somebody was a bad dog.
Somebody was a bad dog, right? And so some people would say, well, that you're just making an assumption based on a photo, right? And so if people would say, you know, I'm just making it, or your number, what is it? 7 is making an assumption. How else would we be able to prove that somebody was a bad dog? And what really happened is that he got into the trash. Juror number 15.
It's the heads down and looks.
Okay, right, demeanor, right, the demeanor of the dog. And we could bring, okay, juror number 38,
Previous behavior.
previous behavior, okay. Juror number 12,
If there's like bite marks.
bite marks, right? We would have to bring you evidence, right? And so those were all very good examples of physical evidence that could be brought. And some other things would be, you know, we could call the testimony, maybe the owner, or call the owner of the dog who was there present during the time. And they can get up on the stand and tell you, hey, it was only me and him in the house. Nobody else came into the house. I was upstairs. I heard him, things like that. And there could also be evidence and photos and videos. Does everyone understand that concept? Okay. So knowing that the standard is beyond a reasonable doubt standard. Well, let me go. Ma'am, what was your card? 56. Juror number 56. So you said you didn't understand the concept that I just, okay, thank you. Okay. So knowing the standard beyond a reasonable doubt, is there anyone here that would hold the state to a higher burden and require 100% proof? If that's you, please raise your card. No? So this is a question that I want everyone to answer, and it's just regarding what is your opinion of the criminal justice system? So you have 4 choices here. One is you think that it's terrible and takes away from the rights of people. 2, you believe that it's concerning and interferes with rights. 3, you think it's helpful in looking out for citizens. And 4, you believe it's beneficial in protecting us from the harmful actions of others. So like I said earlier, pick the one that you most resonate with. I'm going to start with choice number 1. If you most resonate with choice number 1, please raise your card. Okay, what about choice number 2? You think it's concerning?
Hold on, can I get those numbers?
Oh, I'll hold.
Okay.
2, 6, 22, 24, 28, 30, 31, 40, 46, 47, 48, 36, 51, 57, 65, 67, 68, 73, and 74. Okay, if you align with choice number 3, you think it's helpful, please raise your card. Okay, so that's gonna be 3, 8, 12 through 14, 15, 18 through 21, 25, 29, 32, 37 through 39, 42 through 44, 49, 52 through 56, 58, 61 through 64, 66, 69 through 72, and 75. And then if you align with choice number 4, you think it's beneficial, please raise your card. That's 1, 2, 4, 7, 9, 10, 16, 17, 23, 26, 27, 33 through 35, 41, 45, 59, and 60. Thank you. So now I'm going to talk to you about the offense. So the offense here in count 1 is murder. And these are the elements that I was talking to you about. So 1, we have to prove the offense date that on or about a certain date in Bexar County, Texas, the defendant did intentionally or knowingly cause the death of the victim. Okay, so there's 2 ways that the state can prove the offense of murder. 1 is the did intentionally and knowingly cause the death of the victim, or we can go by paragraph 2, which is did cause the death of the victim by committing an act that is clearly dangerous to human life with the intent to cause serious bodily injury. So serious bodily injury is legally defined as something that caused substantial risk of death or serious permanent disfigurement. Regarding the mental state, intentionally is legally defined as a conscious objective or desire to engage in the conduct or cause the result. So when I think about that, I think, did you mean to do that? Knowingly is legally defined as being aware that the conduct is reasonably certain to cause the result. So when I think about that, I think, did you know that result could likely happen when you did that? Regarding the mental states, the law does not require you to be a mind reader. Okay, you can infer that. You can infer intent from words, actions, facts, and circumstances, and we'll kind of talk about that in depth a little bit more in a little bit. So in Texas, the judge did talk to you all about the law of parties, right? And so what that means is that in Texas, a person can be criminally responsible for his own conduct, or he can also be criminally responsible for the conduct of another for which he is criminally responsible, or both, okay? So basically what that means is that each party to an offense can be charged for the same commission of the crime, and you can examine the events before, during, and after the crime. So let's look at the second line, how somebody becomes responsible for the conduct of another. And so the law says that a person is criminally responsible for the conduct of another if that person acts with intent to promote or assist in the commission of the offense. And in that acting and assisting, he either solicits, encourages, directs, aids, or attempts to aid the other person commit the offense. Okay, does everybody understand? We'll talk about it in a little bit more detail, but does everybody kind of understand that? Juror number 56, you do not understand that concept. Thank you. Okay, so we're going to explore the law of parties through this hypothetical. Okay, and so when you look at the screen, there's 3 people on the screen. The gentleman in the white shirt is Nate. The one standing directly next to him is Naz's employee, And the person that you cannot see is named Nas, okay? So let's look at the facts and circumstances in this hypothetical to determine some things. So here are the facts. Nate had a contract with Nas, and Nate did not fulfill his contract. Nas and his employee are out enjoying a night on the town, and they run into Nate at a local business. Nas goes and confronts Nate, okay, and engages in a verbal altercation with Nate. During this verbal altercation, Nas knows that his employee is armed with a knife, and Nas directs his employee to take care of Nate, okay? Nas's employee then stabs Nate, causing his death, and both Nas and his employee flee, and they're later charged and convicted of murder. So, knowing those facts that I just explained to you, let's use the facts and circumstances to determine what was the intent of Nas and his employee. What was their desire? Juror number 12. Okay. Does anybody disagree with juror number 12? I couldn't hear. His answer was to murder Nate. Does anybody disagree with that? Juror number 68, what are your thoughts?
I would need more information. Maybe he just wanted to ask him to do it.
All right, so please stand where you're speaking so the court reporter can hear.
If they intended to murder, they wanted to confront him about the money owed or the job he completed.
Okay. Does anybody have the same line of thought as what is your number?
My name?
Your number.
Oh, it's 58.
68. Who agrees with juror number 68's take on that? Please raise your card. Okay. That's 30, 37, 38, 36, 41, 47, 67, and 74. Okay. And looking further into that, what result do you think was reasonably certain to happen when Nas tells his employee take care of him, and he knew that he had the knife, and he tells him take care of him? 37.
He was gonna get hurt in some way, shape, or form.
Okay, so that's kind of going to, what we talked about, an act clearly dangerous to human life, right? Okay, does anybody disagree with juror number 37's assessment on that? Okay. Now let's look at the factors that make Nas's employee criminally responsible for the murder, for the stabbing. I'm gonna call on you. Do you have any idea of what would make Nas's employee criminally responsible for the stabbing? So in the hypothetical that I've explained to you, what are the factors that you think would make Nas's employee criminally responsible for the murder?
He stabbed him.
Actually stabbing him, right? Right. So using the deadly weapon to stab Nate. Regarding deadly weapon, there's a legal definition for that. So a firearm, right, is a per se deadly weapon, but really anything that in the manner of its use or intended use is capable of causing death or serious bodily injury is considered a deadly weapon. So like in this hypothetical, because the knife is capable and did cause the death, then that would be considered a deadly weapon. Does everybody understand that? Okay. So now let's look at the factors that would make Nas criminally responsible for the stabbing. I'm going to call on you, juror number 3. Do you have any idea what factors would make Nas criminally responsible under the hypothetical that I've posed to you all? No. What about juror number 4?
Well, he mentioned to the other person to kill the other.
Okay.
To find out, to go on after him.
To take care of him.
To take
Okay.
care of him.
I think that's juror number 4. Juror number 15.
Yeah, words came out of his mouth.
Okay. And juror number 7.
And he also knew that he was armed and
Okay.
with a deadly weapon.
Thank you. Does anybody disagree with their answers? If you do disagree with that, raise your card, please. Because he's the one that goes to confront Nate, right? He knows that his employee is armed, and then that direction, right? He directs the employee and gives the order to take care of Nate, right? And that comes from the law that I earlier explained, the aiding, directing under the law of parties, okay? Does everybody understand that concept with the exception of juror number 56? Okay. So knowing the law of parties, right? Nas didn't commit the stabbing, his employee did, but he can be charged and convicted of murder as a party under the law, as it is, okay? And that is because we've just talked about the direction, because that's what the law is. A party to an offense may be charged and convicted of the crime if he solicits, encourages, directs, aids, or attempts to aid the other person, okay? So this is a Willie roll question. Does everybody understand the law of parties as I've explained it to you all? Okay. Does anybody here disagree with the law of parties as I've explained it to you all? If you do, please raise your card. Okay, so everyone here is saying that they understand the law of parties and that they can follow the law that's given to them by the court if they're selected to sit on this jury. Okay. So now I kind of want to explore, because the example that I gave to you all was the directing, right? So I kind of wanted to see, does anybody have any examples of facts that they could give regarding soliciting, encouraging, or aiding or attempting to aid? So I think I'll call on you. What's your number, ma'am? Oh, juror number 5. Can you think of any facts that would count as soliciting or encouraging or aiding?
You want another example besides the one that you used?
Yes, please. 'Cause mine was direction, right? Directing.
Want an example from history, or you
Or
want?
just something that comes to mind.
You know, being told to do something, especially by an employer, I think, you know, that definitely counts as soliciting.
Okay.
Encouraging, I think if you're present at the time, you know.
So that is one thing. So the law says that somebody that's merely present, that's not enough, right? But so that's why the law kind of accepts the solicits, encourages, aids, or
Well, I
attempts
wasn't
to aid.
really finished. I was.
Oh,
say,
I'm
if
sorry.
You're present and like, you know, encouraging the person.
Right.
For instance, I would sound like Nas was encouraging his employee.
Okay.
So like if you're not prohibiting protesting, running away, and you're like fully supportive of the crime
Yes,
that's
ma'am.
happening, I would consider that.
Okay. Thank you so much. And I'm sorry that I interrupted you. And then juror number 12, you had to raise your card. Did you? Okay. Very good. Does anybody disagree with that?
We couldn't hear.
Oh, he said if you would, can you repeat it?
If they were like asking for help, like going out and saying, hey, I need help doing this crime or whatever, to my friends or family.
So going asking for help, like, hey, I need you to help me do this. Okay. 75, you had your card up. Did you have some?
All right, if y'all can remember to stand.
Sorry.
It's okay.
Yeah, I was saying maybe aiding because we should provide the person with a deadly weapon. That's an example.
Okay, that's very good. So thank you all for your participation. So some of that, I kind of hit the same point that you did, right? For solicits, Nas asked his employee to commit the murder. Encourages would be like that verbal, it could be something as simple as just verbal encouragement during the commission of the crime. And then the aids or attempts to aid is like the getting away driver, what jurors number, I think it was 5 and 12 had kind of explained to you all. Another thing with the law of parties is that there's this aspect of reasonable foreseeability. Okay, so even, and this is kind of going to the point that, ma'am, I forget your number, 68 was talking about. Even if you didn't go to the location with a specific intent to commit the offense, you can be found guilty of the offense if you should have anticipated it. And so what are facts that would lead to that anticipation and the hypothetical that I've explained to you all with Nas and the employee? 59.
The employee, or sorry, the owed money.
Right, so the money aspect of it is kind of the motive. And then, right, the whole idea of going to confront somebody with this motive that you need to get something back and you're possessing a deadly weapon, right? Does anybody disagree with that? Now, I have this question that I want everybody to answer. And so it's a statement, and I want to know if you agree with the statement or disagree with the statement. And so what the statement is I don't believe that our judicial system should be prosecuting individuals like Nas under the law of parties. So, right, and the hypothetical, Nas is not actually the person that does the stabbing, but he is still criminally responsible for the aiding, directing, soliciting. So who agrees that people like Nas should not be prosecuted? If you feel that way, please raise your card. Okay, so everybody believes that people should be prosecuted under this subsection of the law. So I'm going to kind of change some of the facts and circumstances regarding that, right? So I'm going to read you this set of facts using the same actors. So Nas and his employee, instead of the stabbing, they physically assault Nate, causing his death. Okay, they're both physically assaulting Nate. The medical examiner determines that Nate died from blunt force injuries to his head. However, they're unable to determine who delivered that final blow that caused Nate's death. Okay, Nas and his employee flee, and they're later charged and convicted of murder. So regarding the facts and circumstances and the law of parties, as I've previously explained it to you all, is there anyone here that says that's an issue for me if you can't determine who actually delivered the fatal blow, even knowing that both of them were beating at the same time? Juror number 30. Can you kind of let me know your thoughts on that?
I think that way, because,
Sorry, I'm gonna have to ask you to stand up.
I believe that one party can get cold feet, so the other person could have continued doing it or whatnot, and he could have did it, but we don't know.
Okay. But you understand that, right? The acting in concert together, that's the law, but you're saying, you know, depending on the circumstances, you think one party shouldn't be prosecuted? Yes?
Yeah.
Okay. Does anybody agree with juror number 30? So in this hypothetical, let's look at the factors that make Nas and his employee criminally responsible, right? Both of them participated in the beating. So for guilt, innocence, right, whether the defendant is guilty or not, it's immaterial who caused the fatal injury because they were both participating in the act, okay? That was their intent and they were knowingly doing it. Does everybody understand that? Okay, does anybody have any questions or disagree with that? So now I want to talk to you about types of evidence that you can possibly see in a case. So does anybody, I'm going to call on you, juror number 8, because I haven't heard from you. Do you have any idea of types of evidence that you would maybe see in a criminal case? What type of evidence would you expect to see for the state to prove that the defendant engaged in the conduct he's charged with? Something physical. Okay, juror number 9.
I would say like video.
Maybe video. Juror number 10. Blood or knife, that's good. That's 11. Bruising. Okay, so maybe some type of physical injury. I'm gonna skip over you. 13. DNA. Okay, that's possible. 14.
Maybe there's like a audio recording of a conversation.
Okay, so those are all good examples, right? And so while the state may bring you some of the evidence that they described, like photos or videos, the main thing that I want to impart on you all is that testimony is evidence, right? And so the state has to call witnesses to prove the facts that are alleged, right? And so knowing that, you may hear from a plethora of witnesses, right? It could be police officers, it could be civilians, lay witnesses, and the judge kind of talked to you. The defendant, in their case in chief, he could choose to testify. If he chooses not to, you cannot hold it against him. And then they can bring any witnesses that they choose as well. But regarding witnesses, you all are the exclusive judges of the facts that are proven, the credibility of each witness, and the weight to be given to their testimony, okay? And so kind of moving on from that, I have this kind of rhetorical question that I want to ask you, and that is, what does a victim of crime look like in Bear County, Texas? So what is your number, 6? Okay, do you have any idea of like what a victim looks like here in Bear County? Okay, but that's kind of why it's rhetorical, right? Because it could look like any one of us, right? It could look like anybody in this room. It could look like someone that we know, love, or care about. And so kind of what I'm getting at is, does a victim have to be a perfect and wholesome person to be a victim? No. Does anybody say yes, they do need to? Okay. Sir in the red. Were you gonna raise your card and say something?
Oh, no.
No. Oh, no. And so can a victim of murder be unlikable and still be a victim? And because who picks the victim of the crime, right? The defendant. And so knowing that, I was gonna ask this, can anyone think of any examples of unlikable people being victims of a crime? But I think I'll just skip over that. And has anybody here seen the movie Pretty Woman? If you have, raise your card. Okay. And so there are 2 characters in that movie, right? Vivian and Edward. And in the movie, Vivian is engaging in prostitution, right? And she meets Edward, and in the movie, things go pretty well for them. But let's say that things didn't go so well for Vivian. Let's say that she's engaging in prostitution. She goes and spends the night with Edward. During the night, something bad happens, and Edward kills Vivian. Does Vivian still deserve justice even though she was engaging in prostitution?
Yes.
Okay, does anyone here say that, know that her case means less because she was engaging in a crime at the time of her death? So I have this question I want everyone to answer, and it says, when the victim puts themselves in danger, the importance of the case is, and you have 4 choices. You have very low, there are far more important cases to be dealt with. Low, not as important as cases dealing with innocent victims. High, they should be treated with the same respect. And very high, every crime is serious because it affects our community. So I want you to pick the choice that you most align with. So the last choice was very high, and it says every crime is serious because it affects our community. Okay, so if you identify with, you think it's very low, please raise your card. Okay, what about low? Raise your card. High. Okay, so that's 1, 3, 9 through 13, 15, 20 through 21, 22, 24, 25, 27 through 29, 31, 35 through 39, 41 through 43, 46, 47, 50, 54, 55, 57, 58, 60 through 64, 65, 67, 68, 69 through 73. And then if you think, oh, go ahead, Drew.
Yeah, well,
I'm sorry. Okay, so if you think it's very high, then now please read it. Okay, it's 2, 4 through 7, 8, 14, 16 through 19, 23, 26, 32 through 34, 44 through 45, 48 through 53, 56, 59, 66, 74, and 75. I'm sorry, juror number 3. I didn't hear you. What were you trying to say?
put me on low.
I put you on low.
Yeah,
Okay,
low.
so that's 30 on low. Okay, thank you. All right, now I want to kind of talk to you all about the testimony of a co-defendant. So the judge explained that to you all about the accomplice witness rule, right? But when I want to explore it through this hypothetical, right? So Naz's employee seeks to testify against Naz. Now, knowing that you all are the judges of the credibility and the facts that are proven through the witness, Is there anybody that would hold it against the state if the state did call the co-defendant to testify? If you would, please raise your card. Okay. And then the judge kind of explained, right, that everyone has the right to remain silent, right? Any accused person. And so just like the state cannot call the defendant to the stand, the state cannot call the co-defendant to the stand unless the co-defendant consents to that, okay? So would anybody hold it against the state if they did not hear from the co-defendant? If that's you, please raise your card. So I want to know you all's thoughts on the testimony of a co-defendant, right? So you have three choices here. You can find it trustworthy, and this is just your general thought, right? Because I've already explained the law to you. Once the co-defendant, if he was called in any case, takes a stand, you would be able to assess his credibility and whether you believe him and whether there's additional evidence to support what he's saying. But just generally, you have three choices here, right? One is trustworthy, two is no confidence, and three is start on an even playing field. So trustworthy says you think that he would probably be the best witness because he was present during the commission of the offense. No confidence means you would automatically find them less credible because they had a role in the offense. Or start on an even playing field means that you can listen to what they have to say and compare it to the evidence that has been presented. Okay, so if you most align with trustworthy, please raise your card. Okay, what about the no confidence? So that is 1, 3, 4, 6, 7, 8, 11, 12, 15 through 17, 22, 28, 30, 31, 34 through 36, 37, 38, 40, 43, 44, 47, 49, 50, 61 through 63, 65, 67, 72, and 75. And so those of you all that have your cards raised for no confidence, because you are the judges, right? If you were able to assess the demeanor of the co-defendant and whether there's other additional evidence that could support what he is saying, would that be able to change your mind that you would be able to believe him if there's stuff to support what he said? Or would you just disregard his testimony in whole? So who here says even if there's additional evidence that can support what the employee, like Naz's employee would say, I just still wouldn't be able to believe a word that comes out of his mouth. If that's you, please raise your card. Okay. So that's 1, 11, 28, 30, 31, 47, 67, and 72. Okay, and so you all that I just named your cards out that you just wouldn't be able to believe what he said. Can you please read your card again? Okay, and so just knowing that, you would not be able to start him on the same playing field as every other witness. Is that correct? Juror number 1?
Yeah.
Juror number 11?
So if there's evidence.
I'm gonna come back to you. Juror number 30? I can't hear you.
Yeah.
Okay, juror number 31. Juror number 28.
Yes.
Juror number 47.
Yes.
Juror number 67.
Yes.
72.
Yes.
Thank you so much. Okay, juror
So
number 40.
if there's more evidence, that's what you're trying to just say.
Yes, sir. So I think maybe you'll probably align with this choice and if you align more with this choice, please raise your card and it's that you can start the co-defendant on the same even playing field as every other witness and then make a determination of whether you believe him or not based on all of the other evidence and whether it supports what he's saying. So if you can do that, now you please raise your card. 2, 4, 5, 8 through 10, 13, 14, 18 through 21, 23 through 27, 29, 32 through 34, 38, 39, 41, 42, 44 through 46, 48, 51 through 56, 57 through 60, 64, 66, 68, 69 through 71, and 73 through 70. Thank you. Now, does that,
Jeanette's-
okay, this question that I have for y'all is, would anybody hold it against a witness if you don't like the way they look? Okay, so that's kind of getting back to, you can start everyone on the same playing field and adjust based on their credibility as you assess it. Is everyone in agreement with that? Okay. So regarding this, one thing that I did want to let you all is that the state does not have to prove a motive for the killing, all right? When I explained the elements to y'all, motive is not there. So some murders are committed and we don't know why. What I need to know is, do you all understand that motive is not an element of the offense? And would you all still be able to render a verdict not knowing what the motive is? Okay, so if you say, no, I need to know what the motive for the killing is, please raise your card. Okay, that's 2 through 4, 8 through 11, 24 through 26, 29, 30, 31, 37, 36, 40, 46 through 49, 57, 59 through 60, 61 through 63, 65, 67 through 68, 69, 71 through 74, and 75. Okay, so y'all that just had your cards raised, right? You understand that the law does not require the state to prove the motive. Is that correct? You all understand that? And so who here is saying that they are going to require the state to prove the motive, even though the law does not make us do so? Raise your card. Just juror number 30. Okay. Does she need a first?
Yes.
County, Texas. So you have one is that you have a very low opinion, 2 is low, 3 is high, and 4 is very high. Okay, so I want you all to pick the choice that you align most with.
Are you asking about law enforcement here in like San Antonio, Bear County, or are you asking in general, like across all of them?
In general, just your opinion of law enforcement in general, okay? So if you align most with choice number 1, please raise your card. Juror number 30 and 71. So I don't mean to pry, but 30 and 71, is this kind of based on an experience that you've encountered yourself or someone that you know and love? Personal experience?
Ones I love.
Okay. Okay, and so it's fair to say that, you know, this personal experience has weighed on you all pretty heavily. And so you would not be able to disregard that personal experience and assess the credibility of the witness, police officer that might possibly testify. Is that correct?
I'm like that,
Sorry,
I'm gonna say I'm more of a 2 on that aspect then.
then more of a 2.
Yeah.
So are you saying that you would be able to believe the officer, or are you gonna start him, you know, not on an even?
Low end.
So you can't start the police officer on an even playing field as everyone else, is that correct? Juror number 30?
No, ma'am.
Okay, thank you. 71, can you start the police officer on the same level playing field as everyone else, or would your personal experience kind of make you automatically not believe what he has to say? Okay, and what's your number again? 71, she said she could start on. Okay, if you align more with choice number 2, please raise your card. Okay. That is 5, 6, 8, 11, 12, 22, 24, 28, 29, 31, 36, 40, 37, I'm sorry, 43, 40, 46 through 50, 57, 61 through 63, 65, 68, 69, 73, and 74. Okay, so for you all that were with choice number 2, then I pose the same question to you all. Are you able to start the officer on the same playing field as everyone else, or are you gonna automatically start him below everybody else because of your feelings towards law enforcement? So, okay, if you can start the police officer on the same level playing field, I'm the acting officer, right? If you could not place the officer on the same level playing field as everyone else, if you would place him below that, please raise your card. Okay, that's your 8, 11, 6, 22, 28, 31, 46, 63, 65, 69, 73, and 74. Thank you all so much. So the judge went over the range of punishment with you all regarding the murder, right? It's a first-degree felony. The range of punishment is 5 to 99 or life in prison with a maximum fine of $10,000. So has anyone here ever served on a criminal jury before? If you have, please raise your card. Okay, that is 12. And regarding punishment, did they go to the judge or the jury for that? Not guilty, okay. 20, have you served on a criminal jury before? Okay, and regarding punishment, did they go to the judge or the jury for that?
I just know they were guilty, so I think they went on to do like the sentencing.
Okay, thank you. 35,
It was a capital murder
okay.
jury.
Did they go to the judge or the jury for punishment? Jury, okay. 43, judge or jury for punishment? Jury. Okay, 52, judge or jury for punishment?
Either.
It was dismissed? Okay, thank you. And 58, judge or jury for punishment?
Judge.
Thank you so much. Okay, so the judge kind of talked to you all right about the phases of punishment. I'm gonna skip through this because I'm running low on time. But regarding sentencing evidence, right, there are a lot of things that come into play in sentencing that are not relevant in the case in chief, which is the state bringing the witnesses to prove the offense of murder. Okay, and punishment, you can look at a wider lens of the defendant. And so what that looks like is maybe prior, if he committed anything after, are there other victims, the character, all those good things. And so what I want to know is what you all think is the main purpose of sentencing. Do you think that it's 1, punishment? Do you think that it's 2, deterrence? 3, making amends? Or 4, rehabilitation? Okay, so if you align more with rehabilitation, please raise your card.
What it should be, or what if you think?
What is it to you? What is the main purpose of
I think
punishment?
the main purpose should be
Yes.
rehabilitation.
Okay,
That's
if you
what-
align, if you align with rehabilitation, please raise your
What
card.
number is that?
Oh, sorry.
That was 41. Okay, so that's 3. Let me flip here.
Oh, I'm sorry.
5, 6, 12, 29, 41, 44, 57, and 73. So if you align most with punishment, then please raise your card. Okay, so that's 1, 2, 7 through 10, 15 through 21, 22 through 28, 30 through 36, 37 through 40, 42, 43, 45, 47 through 49, 51 through 56, 67, 68, 70, 71, and 74. Okay.
I have a question.
Go ahead.
I mean, like, what if you just feel like the answer could be a little bit of everything.
That's fine. I was just,
So many of these, I feel like
Yeah.
I don't align with just one.
okay, that's fine. Cause we're short on time. It's just, it's
1 minute.
okay. And so is there anyone here that cannot sit in judgment of anybody for moral, religious, or any other reason you feel like you cannot sit in judgment of another person? Okay, that's juror number 2 and juror number 16 and 67. 17, 30. Okay, guys, please raise your cards all at one time. If you feel that you cannot sit in judgment of another person for a moral, or religious, or personal reason, please raise your card. 2, 3, 11, 6, 16, 17, 30, 31, 40, 44, 47, 49, 55, 67, 72, and 75. Okay. Okay, that is my time, so thank you all so much.
All right, ladies and gentlemen, I am going to give the defense 48 minutes. I gave the state 48 minutes as well. So defense, you may proceed.
Thank you, Judge. It's afternoon. Good afternoon. So the judge did a very good job of breaking the ice and explaining a lot of the items, a lot of the issues that we're going to be dealing with. The state also did a good job. Can you put up the dog
Oh, yeah.
photo? But as juror number 5 was talking about, there was a lot of gray area that the state kind of pushed you into making a decision. And I agree with the state as far as pushing you, because this is the voir dire. And voir dire means to tell the truth in French. Okay, I went to law school in New Orleans, so I picked up a lot of French. But this is the time when we can actually have some fun and understand this is a murder case. So this is an extremely serious case. In fact, Marco here, this is the most important thing in his life. And so while I can joke about this regarding the voir dire, because the purpose is for the state to know as much about you and for the defense to know as much about you. And what I agree with both of them on, the judge and the state, is that we need you to answer questions. Because if we don't know enough about you, we can't determine whether you'll be a fair and impartial juror in this case. Clearly, the state wants people who are going to favor them, even though they need to be fair, and they are. And we need people who need to be fair and impartial, but we want the best people who will understand all of the evidence in this case on behalf of Martha. And so it's important that we know everything. There are no right or wrong answers. Okay? The prosecutor said it's a judgment-free zone, and that's completely true. We all have our biases, we all have our prejudices, and most of the time those don't affect the law. Okay? Sometimes they do, but in this case, we need to know what those are so we can determine whether you should be on this panel of 12. She used the example of Willie and drugs, right? I mean, he clearly loves drugs or marijuana, and he wouldn't be the person to sit on a drug case because I don't think he could follow the law because he doesn't regarding marijuana. Okay, whether you agree with him or not, that's just a reality. So in this case, and you heard that you are going to be the triers of the facts, and the judge is going to be the trier of the law. What does that mean? It means the judge will give you the law. The state and Marco and I are going to produce evidence before you, and we don't have to. Remember, the burden is beyond reasonable doubt as to all the elements, each and every element in this case against Marco, those charges you heard. They have to prove each and every element beyond a reasonable doubt. So they bring all the evidence. We can bring evidence if we want, but we don't have to. They have to prove the case. We don't have to do anything. We could sit here and play games. Clearly, we're not going to do that because this is too serious. But understand, they have to do everything. We don't. And as triers of the facts, you're gonna hear evidence that's gonna come from this witness stand. Okay? And it's gonna be a plethora of people. You're gonna hear from, I imagine, police officers. A medical examiner, because it's a death case, meaning somebody died. You might hear from ballistics if there's guns. You might hear from a fingerprint expert if there's anything else, like a knife or anything else that was touched. They're going to decide what they bring you. Okay. And so you have to decide when this witness is up here, whether you believe that witness beyond a reasonable doubt. What does that mean? We all make decisions every day in life, right? Did everybody drive here today? Yes, right?
Yeah.
Or they got dropped off. On the way here, just like I did, and I do every day, who do you see at the corners, at the stoplights, the stop signs, the lights? Who's on the corners?
Almost.
Who do you see?
Pedestrian.
Okay, who else? Who's at the corner holding a sign that says something?
Homeless.
Homeless peddlers, right? And they want money. Who here, when they see them, gives them money? Anyone? Juror number 20, why?
I just have a special heart for those people, and you never know why they're there.
You feel bad for them, trying to help them. Juror number 22.
Yeah, if I have like 10 bucks in my wallet, like I got no reason to keep it.
Okay, that's juror number 68.
Everybody has a story.
And so number 41, what are you going to tell us?
I don't give money, but if I'm feel led, then I might go, like if I might go buy diapers, or I might go around the corner and pick up a meal and give it to, if I feel the spirit leading me.
Because you're trying to help them, right?
But I
Trying to
don't
do
give the
good.
money because I don't know what they're gonna use it for.
Okay, I always feel bad when I see them because I try to be a good person. I try to help people. You know, do unto others as you would hope that they do unto you. Love your brother and your sister, love your neighbor, right? So let me give you an example. Years ago, maybe 20 years ago, I needed gas. I drove to the side of downtown here on Laredo Street, went to the Exxon, pulled up, gassed up my car. This truck pulled up with this young girl, and I'm assuming her boyfriend in the truck. She comes over to me and she's like, "Sir, could you help us? We ran out of gas. We're running out of gas, and we're trying to get down to Corpus to our family. Can you give me $1, $5 or something?" I had a great day that day. So I pull out my wallet and I give her a 20. Okay, it made me feel real good. Start walking to my car. She takes the 20, smiles, gets in the car, and they drive off. They didn't need any gas. That was the last time I ever gave a peddler money. Okay? Because not all of them are out there in need. Okay? There's a peddler at the corner of Broadway and Newport 10. Several. They're there every day. I meet a lot of my clients at the restaurants in that area. And while I'm sitting there, I watch the peddlers walk from their car to the corner, some of them walking perfectly fine, better than me. But when they get to that corner, all of a sudden they have a bad leg. They sit in a wheelchair. They bring a dog. And they ask for money every single day. And I'm in that area so much that every time I go, they watch me. And they wait until I go in the restaurant before they start walking around. What does that tell you? It's a scam, right? And unfortunately, it's hard to tell. But when you see people, you try to make a decision as to whether they actually are in need or not, correct? Now, how do we do that? We use our simple common sense, don't we? This will date me, but I've used this example forever. Arnold Schwarzenegger, everybody knows Arnold Schwarzenegger? Yes, right? When he was young, Mr. Olympia, Mr. World, walking around and tights, underwear, whatever. If you were to see him on the corner back then, holding a sign saying, please, homeless, need money for food, and he's busting out with muscle. Okay, he even has oil that Diddy didn't buy up, and he's got it all over him, so he's glistening in the sun. Every little cut in his body is showing, and he's standing there. His hands are manicured, his feet are pedicured. He looks fantastic as a male specimen. Are you going to go give him money because you think he needs money? No, right? You might go over and take a picture with him, but you're not going to go give him money. So we use our simple common sense to do that. We do it every day. When you're parking in a garage and the car next to you's over the line, are you going to go find another spot? Probably, so your car doesn't get dented. And that's the kind of simple common sense I need from all of you when you're listening to witnesses. Can everyone promise me that? Yes, right? We do it all the time. Why not do it now? So, in the examples that the prosecutor gave you, you only heard kind of the theoretical side that she gave you. Regarding this photo, we talked about, and one of the jurors said, somebody's been a bad dog, right? Well, looking at that photo, if, let's say this dog was called Blue, would Blue be guilty in this case, beyond a reasonable doubt, as to causing that mess? Yes or no? Juror number 5, why not?
Well, I didn't see him do it.
You didn't see him do it, what else? Maybe there's another dog that's not in the photo.
Or a kid.
Or maybe there's a young kid that's not in the photo and the dog feels bad. Somebody mentioned the dog looks like he feels bad or guilty because he knows what's going to happen to the kid when the parents find out. So there's a lot of things going on here that you cannot assume. You cannot infer. Remember, the evidence they have to prove is beyond a reasonable doubt as to each and every element. Our country celebrated the 250th, correct? Of our nation. Some people thought it's kind of a joke. Some people thought it's incredible. But if you really think about our country and how we're viewed across the world, and I watched a bunch of videos last night about the World Cup and how all these Europeans and people from around the world are shocked at what America and Americans are really like. The beauty of our criminal justice system is that it was founded through this country under the Constitution. And what people seem to forget is that when the founders started this, this was an experiment. An experiment. They didn't really know what they were doing, but they created this government the best way they could. And our government has withstood the test of time for 250 years now. And what makes our criminal justice system different than any other country's is that a defendant, somebody who's charged with a crime, is innocent until proven guilty, and only if proven guilty beyond a reasonable doubt. Other countries, you're guilty and you must prove yourself innocent. And that's why when the judge talked about what our country requires of you, I know it's a hassle to stand in that hall all day. I know it's a hassle to sit here and have to listen to people you don't know, or be involved in something maybe you don't care for, you don't like. But on behalf of Marco here, I'm thanking you all for the time you're spending here. And I'm asking that you continue to view it as seriously as possible, because you're part of this experiment. Our laws change based on how verdicts come out, on how politicians see things, on how people vote. And when people stop getting involved in those things, we get laws that maybe we don't like. Our country goes in certain ways that perhaps we don't want. So understand that as the triers of the facts, regarding their theoretical examples, you have to be given proof beyond a reasonable doubt as to each and every element. Can you throw the NAS example up there, please? Let's use another example of theirs. Okay. Here, we have NAS on the left, the employee with the knife, and Nate. Okay. Let's say there's a second employee there that's not in the picture. Okay. Under their example, y'all found the employee guilty, right? Because he stabbed and killed him. And then they went further, and there was a direction from NAS to the employee to take care of him. Let's change that scenario. Maybe NAS is a preacher or a rabbi or a priest, and he's a pacifist. And he's also an accountant. He runs an accounting business. And when he told the employee to take care of him, he meant to take him to a room and have him sign a contract saying he owes the money, or he needs to finish the job, or he gets fired. Does that change the scenario? It does, doesn't it? Okay. What about the employee, the second employee that's not in the picture that got charged? There's no evidence regarding that person, is there? And you're going to get the law from the judge, but mere presence alone does not make somebody guilty. They have to prove under the law of parties that that person solicited, aided, abetted, encouraged. They have to show, just like juror number 30 was asking about, right? They have to show all of this stuff to show he or she was part of the team and was looking forward to Nate getting killed. So remember, use your simple common sense and hold the state to their burden as to each and every element. Can everybody do that? Yes, right? Okay. You heard from both the judge and the prosecutor, they covered it pretty thoroughly, that Marco here does not have to testify. What are some reasons, juror number 7, that a person wouldn't testify in their own trial?
Well, I guess by the definition, not to self-incriminate.
Okay, doesn't want to incriminate himself. Juror number 9, why might somebody not testify in a case against them?
I don't know.
Do you feel like somebody should always testify in a case against them? Okay, are you going to hold it against Marco? Juror number 10, can you think of a reason why a person won't testify?
Bias or how people will interpret the information or judge them.
Okay, maybe they don't speak the language very well, right? Maybe they're not good speakers. They say the worst. Do we know people who say the wrong thing at the wrong time without meaning it? Yes, all the time. Perhaps because the attorney says, you know what? They didn't meet their burden, so there's no reason for you to take the stand and risk getting thrown off. Right? Okay. And then there's always the obvious one that they did it, and so they don't want to take it. I have to be upfront with you about everything, okay? I'm not trying to hide behind anything. I want y'all to understand the seriousness of this case. Does it matter whether the story that somebody gives, a witness or a victim, whether it makes sense? Yes, right? Isn't that how we determine credibility? So if you have a really young child testifying, say somebody who's 5, barely speaks the language, correct? Barely understands the language, correct? Are you going to look at them with common sense and say that that child doesn't know what they're talking about? Possibly, correct? They may be the most honest person in a trial, but you're going to use your common sense. Everybody? Yes. What if the child's a little older? speaks the language is in their teens. Okay? Why would somebody get on a stand and swear to tell the truth and lie? Does it happen in our lives? Do we have police officers who lie? Do we have teachers who lie? Do we have politicians who lie? Have we had presidents who have lied? Yes, right? It runs the gamut. Attorneys, judges, accountants. Anyone can take the stand, swear to tell the truth, and lie to you right to your face. It happens every day, unfortunately. But you have to look at them and see whether their story makes sense. Why do we have spouses testifying against their spouse, wife against the husband, husband against the wife in assault cases? Maybe because they were assaulted, correct? Is it possible they created the story? Yes, right? In divorces, do lies occur on the stand? Yes. And sometimes there's reasons and sometimes there's not. Now, the prosecutor and the judge talk to you about accomplice witness testimony or a co-defendant taking the stand against their co-defendant, okay? Why would a co-defendant take the stand? Again, number 6. Why would a co-defendant take the stand in a criminal case against somebody that they were with and is charged with the same crime? No idea? Juror, what do you think? Maybe they get less punishment, they help the state. Does that mean they're telling the truth? Okay. 14. Could they get up there and tell the truth? Yes, right? They could also get up there and lie. They could also get up there and tell partial truth, couldn't they? This jury, unlike many of my others, didn't really give much credibility to a co-defendant who testifies. I find that very interesting and enlightening, okay? But remember, if they do testify, you have to look at them and decide whether you believe what they're saying to a reasonable extent. You believe them beyond a reasonable doubt. If you don't, you can discard their testimony completely. That is the power you have as triers of the facts. You get to decide what you believe and what you don't believe. And what you don't believe, you throw out. That's very important. It's very powerful. That's one of the beauties of our criminal justice system. That Marco gets tried by a jury of his peers with common sense in this world. Is there anyone here who's been a victim of a violent case? Because and remember, I'm not trying to ask any super personal questions. If I ask you a question that you don't feel comfortable talking about, we can approach the judge later and talk about it. But I need to know these things. Okay? But is there anyone here that's related to anyone that's in a DA's office or the Bexar County DA's office? I have to ask that because a couple of years ago, we picked a jury, and as the juror was being seated, he called the bailiff over and said, I got to tell the judge something. Judge said, what is it? My daughter works for the Bexar County District Attorney's Office. Now, that doesn't necessarily mean he'll be unfair and impartial in a case where he sits, but it's something that we should know about, right?
Sir, that includes the sheriff's department or just Bexar County here?
Anywhere. Okay, who you related to?
Richard Escobedo, who's the sheriff.
Okay. And we'll get to law enforcement later, but thank you.
I don't know this matter at all, but my mom works in Pearland, Texas, so she lives over in Houston area. So it's not, I don't know if it has anything.
Okay, and she works for the PD there?
No, she works for, I believe, the DA.
Okay. Doing what?
She's a lawyer.
Okay. So she's in the DA's office. Okay,
I'm not sure if I've got that right, but yes, she's a buyer.
thank you. It's good to know. See, I mean, stuff like that matters in our deciding whether we want you on this jury or not. Now, regarding punishment, both the judge and the prosecutor talked about it. But what's very important is, in order to sit on this case and be fair and impartial, you have to be able to consider the full range of punishment. I believe the prosecutor asked you about the low end or the high end, but you have to consider both ends. Now, this is a murder charge, so punishment on that is 5 to 99 years in prison. So is there anyone here who, if you got chosen to be on this jury and a verdict of guilty is found, that you're automatically going to go to one number? Okay, let me give you an example. My best friend, he doesn't have his own children, but his sister had 4 girls. He basically raised those girls like his daughters. I talked to him about all my cases, and on any sex type case, he tells me, if the young girl, the victim, gets on that stand and says that your client did something to her, I'm going to find him guilty. And I'm like, well, hold on. What about all of the evidence, the nuances and stuff? He's like, I don't care. If she gets on that stand, whether she's telling the truth or lying, I'm going to find him guilty. Okay. Could my best friend be fair and impartial on a sex case? No. And he should never sit on one of those cases. And I've told him that over the years. So in this case, is there anyone here, because it's a murder charge, cannot be fair and impartial and look at the full range of punishment from 5 to 99? Number 1, number 11, number 2, 6, 4, 26, 30, 31, 35, 36, 40, 47. Keep your numbers up. 55, everybody. 40, 47, 55, 56. Nobody on this side? Okay, now understand, everybody with their numbers up, keep them up. The judge is going to tell you, I give you the law. If you find him guilty, you have to consider the full range of punishment. Are you telling me now, even if you're instructed to follow the law, for whatever reason, personal reasons, religious reasons, moral reasons, just your ideology, you cannot follow that law? Keep your numbers up if that's the case. Number 4, you came down. Anyone else come down? And we got 1, 2, 8, 11, 30, 31, 35, 40, 47, 55, and 56, and 36. Okay. Now I'm going to sit down. I hope you don't take that as a sign of disrespect and go through what you guys answered, because there's questions I need to ask. So if I pass over you, it's that you filled out the form and gave me enough information. Judge, how much time do I have left?
20 minutes.
Now, juror number 1, you were on a civil case. What's the burden of proof in a civil case? If you remember.
Hundreds of evidence.
Okay, preponderance of the evidence. Does anyone know what that means? You look at the scale of justice, the scales here. Preponderance of the evidence means one side just has to prove just ever so slightly, a feather. Okay, and the group that gets it down just ever so slightly, they win. Is that right? Okay. Is that the same in a criminal case? No. In a criminal case, you heard the judge saying that after she was it a trial or a case, or you were a juror, that they changed the law after that. So there used to be a definition for beyond a reasonable doubt. There no longer is, because I think people had problems with that definition. So Today, the burden in this case that the state must prove is beyond a reasonable doubt. It's like this. And they always say, but not all doubt, okay? Well, it could never be all doubt, as they say, because you would either have to be there. Nobody's there that would be sitting on a jury, okay? So that's how important this case, that's how big their burden is. Does everybody understand that? Make no mistake, as to each and every element, it's like this, that they must prove. That's a high standard, okay? Now, regarding the punishment, you have to look and listen to everything that's brought to you and make a decision where you feel, and that's if Marco's found guilty. I'm not saying he is. I don't expect him to. But if he is, then you're going to sit and make the decision as to his punishment on the murder, and it would be between 5 and 99 years. And so you have to look at everything. What might be an example that you give a person who's convicted of murder, something in the low range?
Possible motive.
Okay, like what?
For instance, I've seen interviews where someone's reacting because someone hurt their child.
All right, so here's the thing. I think you all forgot my instruction at the very beginning. Jurors in the box, juror on the front row, you don't need to stand because the court reporter can hear. Everyone else, you need to stand if you can stand so the court reporter can hear.
What I said was possible motive. For instance, what I've heard before where someone did something in reaction to someone else being hurt, for instance, like a child.
So he saw his child being hurt, lost his mind and killed that person.
Correct.
Okay. Or maybe somebody has a aging parent who's suffering miserable, incredible pain, and they go and they euthanize. Okay. Under the law, it's still murder, but you might have some feelings for them, right?
I believe it's worth consideration.
Or perhaps there were several actors and you found that person guilty of the murder, even though they weren't the ones shooting the weapon, using the knife, like in the Naz example, and they were just there and you weren't sure, but you felt that they were guilty and you found them guilty, correct? You might have a little bit more consideration for that person. You might not. Juror number 5, you have law enforcement. Was it just your mom?
My sister's married, again, they live in like Friendswood. So over in the Houston area, but my sister's married to a police officer. I think he's like a mental health officer.
Well, if you're going to hear from police officers in this case, there's always police officers in every criminal case because they have to make an arrest or they have to secure the scene, take evidence. So because of your relation to a police officer, are you going to give police officers who testify more credence, a little slack in their work, or are you going to hold them to the same standard you would anyone?
Same standard. Not worried.
All right. Thank you. Juror number 8, you're retired. What did you do for a living?
I stood, sous chef.
Okay. And did you ever have a significant other? Wife, ex-wife?
Over one time, yes.
What did she do for a living?
Let's give, food server.
Excuse me?
Food server.
Okay. Juror number 9, same question. Did you ever have a spouse or a significant other for a period of time?
Yeah.
What did that person?
Married.
Okay, and what does your spouse do?
We worked for Ford Motor Company.
Okay,
Fred McCollum.
and you also have relatives in law enforcement?
I do.
What's the relation?
I have my cousin's a police officer, SAPD,
Okay,
and then my son is an FBI agent.
so you're embedded in law enforcement? Okay, knowing that, I'm sure you love your son, I'm sure you love your cousin, and you respect them. You hear from officers in this case, are you gonna give them more respect than they deserve? Are you going to assume that everything they say is the truth?
No.
You'll treat them just like anyone else?
Yeah.
Thank you, ma'am. Juror number 11, spouse or significant other,
I got a significant other.
and what does that person do?
She's just a home taker
Okay,
or caretaker or home taker. Homemaker.
it varies, right? Caretaker sometimes. My wife wears all kinds of hats. I'm a lucky man. So juror number 12, same thing, spouse, significant other? Nurse?
Yes.
Okay, and does she deal with the emergency room or people who have been shot?
They're a hospice nurse.
Okay. Unlikely.
Yeah. Hopefully not.
And you were on a criminal case, were you the foreperson?
Yes.
And that was a not guilty?
Correct.
Juror number 13, same thing, spouse or significant other?
No, sir.
Juror number 14? Juror number 15?
That's
Okay, for how long?
5 years.
Long enough?
Yeah.
And what does she do?
Let's say university.
As a nurse? Okay. In the trauma unit, anything like that?
No.
You don't hear horror stories of people who've been shot and brought in or stabbed?
Taking care of people after surgery.
Okay. And you were also in a criminal case. Were you the accused, the complainant, or a witness?
Been accused.
Okay. And like I said, you don't have to answer it here. We can talk in front of the judge. Are you okay answering questions?
Talk from the judge.
Okay. Because I mean, we just have to find out the information. I'm not here to single anyone out, try to embarrass anyone. I just need to know the information.
Thank you.
Number 17, significant other or
Yes.
spouse? What does he or she do?
He works for a repo company.
Works for what? I'm sorry.
Repo company?
Does he have to deal with police all the time?
Yes.
Is that going to cause a problem for you to see officers testify?
No, sir.
Okay, give me fair and impartial.
Yes.
Juror number 18, same thing, spouse or significant other. Number 19, just dealing with cancer.
Yes.
Number 20, you were a juror, was there a verdict?
Yes.
Were you the foreperson? Were you the chosen by the jury to
Oh.
run? Was it guilty or not guilty?
It was guilty.
What kind of charge?
Something to do with the intent to like they didn't kill the person, but it was like their action could have killed the person.
Reckless endangerment?
Yes.
Juror number 21, spouse or significant other.
No.
Number 22, spouse or significant other. Number 23, Miss, is it Lanzel?
Yes.
Now, you said on a civil jury, you understand the difference in the burdens?
Correct.
Thank you. Number 24, Mercedes Briones, spouse or significant other. Juror number 25, same question.
Oh.
Okay, what does he do or she do?
AC work. I didn't hear that. AC was.
Probably pretty busy right now.
Air conditioning.
Number 26, your spouse is retired from what?
She worked, her dad was the owner of a stucco plaster company.
Thank you. Number 27, same thing, spouse or significant other.
No spouse.
And you don't understand the reason why I ask, because I've had a lot of people who put on their retired and nobody asks what they retired from, and they were CIA, FBI, DA's investigator, police chief. And it makes a difference. So number 28, Mr. Moody, spouse or significant other.
Significant other.
Okay. Did what?
She's a teacher, special needs teacher.
Okay. And you served as a juror, what type of case?
I'm not sure. I got dismissed or got
Did they settle or the person pled? If you remember.
I don't remember.
Okay. Thank you. Number 29, Ms. Garcia Pina, spouse or significant other?
Significant other.
Okay, what does that person do?
Construction work.
Thank you, ma'am. Mr. Barry, spouse or significant other?
I didn't hear it.
That was the wrong answer. Yeah, I guess it's not an emergency, so let's continue. Number 31, spouse or significant other. Number 32, you checked off that you were either an accused, a complainant, or a witness in a criminal case. Can you tell us, or do you want to come back?
OWI.
It was the DWI?
Yeah,
And were you the accused, the complainant?
accused.
Okay. Did you get yourself an attorney?
No. Oh, wait, yeah, well, it was like a public defender.
Okay, so you had an attorney. Did you take it to trial? No. Did you take a plea?
Yes.
And did you take a plea because you did it? You were guilty of it?
Yes.
If you were innocent of it, would you have taken it to trial?
Yes.
Thank you, ma'am. Juror number 34, you're retired from what?
Lumber company.
Lumber company?
Yes,
Okay.
retired.
And spouse, do you have a spouse or?
Yes,
What does she do?
I'm retired.
From what?
Dental hygienist.
Thank you, sir. Mr. Rodriguez, Antonio Rodriguez, number 35. You checked off that you have law enforcement in the family?
Yes, Bear County.
What- Cousin doing what for Bear County? Deputy?
No, just patrol, I guess.
A what?
Patrol.
Patrol. Okay.
I'm not too sure on that.
Does your cousin tell you his war story?
No,
Okay.
I don't see it that often.
Because you might hear from either SAPD or Bear County Sheriff's Office in this case. Is that going to influence you one way or the other? You're going to treat him just like you do everybody else. Thank you, sir. Now, Mr. Vasquez, number 36. Your spouse is a chemist?
Yes.
And by that, I mean a legal chemist, right? Doesn't create meth. And so, you may hear from a lab in this case, okay? Or at least an ME's office, I imagine. Because your spouse is into science are you gonna give that chemist more credibility than anyone else? You are or you're not?
I am gonna give more credit.
I'm sorry, I can't hear you.
I am gonna give the chemist more credit.
Okay, why?
Science,
What about science?
you can see that right or wrong, you can't lie.
That's the beauty about it, it's pure, right? But by the same token, do you remember the O.J. Simpson case? Most of us do that are of a certain age, right? What happened with the lab there?
I don't remember.
Okay, does anyone remember?
It screwed up massively.
Okay, the team of attorneys, which were called the Dream Team for media purposes, I believe, brought in evidence to show that the lab had contaminated or tainted a bunch of stuff that applied to that case. And thus the jury didn't look on it fondly. So I understand your feeling about science, because I feel the same way, but will you use your common sense to judge whether what the chemist is saying or the doctor is saying is based on reason and there's nothing tainting it?
If there's evidence to prove all that, yes.
Okay, so you'll use your common sense. Thank you, sir. Okay, Ms. Garcia, number 39, your spouse, did your spouse ever have a job?
Yes,
In what field?
customer service.
Thank you, ma'am.
2 minutes.
Juror number 41, spouse or significant other?
No, that's very.
Number 42, Mr. Domingo, Miss Domingo,
It's,
law enforcement in the family?
yes. My dad was, but he's retired.
From what?
The Department of Homeland Security.
Was he ever a deputy or police officer before that? Do you see officers testify? Is that going to bother you?
No.
Thank you. Number 43, Ms. Schneider, spouse or significant other?
Significant other,
Doing what?
physical therapist.
Thank you, ma'am. Number 44, you're an author?
Yes, I am.
What genre of stories?
A lot.
Any criminal thrillers? And your spouse?
I don't have a spouse.
Okay. Thank you, sir. I look forward to seeing some of your stories.
I hope so.
Okay. Do I have a minute left, Judge?
You have 1 minute exactly.
Okay. So, Mr. Fowler, spouse or significant other? Thank you, sir. Number 46, same question.
Single.
So, since I'm basically running out of time, once again, on behalf of Marco, I want to thank you for being so attentive, and I look forward to having you on this jury.
All right, ladies and gentlemen, I'm going to have you step outside. We're going to call you back in 20 minutes, and don't worry, you will have a chance to have a lunch break after we discover who's going to be on the jury. Please take all your personal items with you and leave your numbers behind, and you are not excused from the courthouse. All right, thank you.